Hello, everybody. Look at what we're talking about today. 3 more arguments an attorney cannot make during closing arguments in a civil trial here in New York. You want to know what this is about? Come join me for a moment as you learn some great information. And today, here's my fancy ticker tape telling you exactly what it is we're talking about. 3 more arguments an attorney cannot make. So stand by as we get you ready. And we're going to have a great time in today's video broadcast. Notice my 3-dimensional ticker tape. Look at that. How many people do you know use a 3-dimensional ticker tape like this, printed on a fancy white piece of paper? That's right. 3 more arguments an attorney cannot make during the course of closing arguments in a trial here in New York. That's what we're talking about today. And that's what we're going to be discussing. 3 more arguments, because you know what? It's really important to know not just what you can do, but what you cannot do. So today we're talking about 3 more arguments that an attorney cannot make. And by the way, if you're joining me for the very first time, go ahead and leave a comment. Let me know that you're here. Say hello. If you have questions during the course of my presentation, I want you to go ahead and ask me those questions. I will definitely get to them. And this will be eye-opening for a lot of people. So we're almost about ready. That doesn't make sense. We're about ready to get started. And we're talking today about 3 more arguments that an attorney cannot make during closing remarks, what we call closing arguments or summations. That's exactly what this is. All right. So now I'm talking about the end of the trial. So let's get ready to get started. No, that doesn't make sense either. Let's get started as I share with you this terrific information. Hi, everybody. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. It's a beautiful day today here in Great Neck. It's bright. It's sunny. I wanted to get this great information out to you. So today we are talking about 3 more arguments an attorney cannot make during closing arguments. So now you no longer have to stand by. We're going to get right to it. All right. So here's the scenario. Let's say you brought a lawsuit against your doctor. You claim that he was careless and that his carelessness was a cause of your injury. And now, as a result of that, you go ahead and ultimately bring a lawsuit against your doctor because a medical expert has confirmed that you have a valid basis for a case. So what happens next? What happens next is that your doctor now gets the lawsuit papers and turns around and says, hey, why are you suing me? Why? I did nothing wrong. That's his first defense, right? So now I'm creating the setup for you to show you ultimately what 3 arguments an attorney cannot make during the course of closing arguments at a trial. So if you're here for the first time, leave a comment, say hello. If not, if you have questions during the course of my discussion, go ahead and leave them. I'll be happy to answer them. All right, so here's the scenario. Now you've brought a lawsuit against your doctor claiming that he was careless. The doctor turns around and says, why are you suing me? I did nothing wrong. And then he says, hey, you know what? If I did something wrong, so did you, Mr. Patient. And then he says, you know what? If I did something wrong, whatever I did not cause or contribute to your injuries. So, isn't that interesting? And then he says, okay, even if I did something wrong, guess what? Whatever I did didn't cause your injuries. And by the way, your injuries really are not as bad as you claim them to be. So those are the typical defenses we find in these medical malpractice cases against doctors here in New York. And just if you're joining me for the very first time, today we're talking about 3 more arguments an attorney cannot make at the time of trial, at the time of closing arguments. So now, your case is fought tooth and nail. The doctor refuses to settle. He refuses to negotiate, claiming that he did nothing wrong. Now, what does that mean for you? It means that you're going to trial. It means that it will be 2 to 3 years before your case winds through the litigation process, and now you ultimately get to trial. So now, at trial, you have 2 weeks' worth of trial. 2 weeks where testimony is being presented, where you are putting on all of your evidence. You're putting on all of your exhibits. You're putting in all... Hey, Steve, nice to see you. So we're up to the seven things? That's right. Actually, if you followed me in the last video, I talked about 3 things, and then my good friend Steve Richardson came on and had a 4th one. So now we're adding 3 more. 3 more arguments an attorney cannot make. So, Jason, nice to see you. Thanks for joining. And yes, Steve, you're absolutely right. We are now talking about ultimately 7 things an attorney cannot say during closing arguments in a civil trial here in New York. So now you're on trial. Your trial is going on for 2 weeks. You put on all of your evidence, all of your testimony, and everything that you need to in order to show that you are more likely right than wrong. And likewise, the defense has done the same. They've put on their medical experts. They've gone ahead and put on their evidence to try and show the jury that, no, you don't have a basis for a case. So what happens next? After all the evidence and all the testimony is presented, now is the opportunity for you and the defense attorney to present what we call closing arguments. Now, you should know something. Attorneys call these summations, or they're going to sum up. And it's the same thing. It's an attorney making closing arguments. Now, what exactly is closing arguments? It's an opportunity for an attorney to piece together everything that's gone on in the trial, not to rehash everything, but to highlight certain things and to have the jury, or to try and get the jury, to reach certain conclusions about why their client is entitled to a verdict in their favor. So an attorney is going to use logic, he's going to use reason, he's going to use passion, many times he's going to use righteous indignation, how dare they do that type of thing, okay? So that's some of the things that attorneys can do, but today we're not talking about things they can do, we're talking about things they can't do. And it's so important to learn not just what an attorney can do, but it's critically important to know what they can't do. Especially if you're, for example, a young attorney starting out, you want to know, hey, what can't I do? Because often that's more important. All right, so let's get right to it. The very first thing that an attorney cannot do during closing arguments is you cannot ask the jurors to step into the shoes of your injured client. Now, what does that mean? We call that the golden rule. Basically, you turn to the jury at the end of the trial and say, ladies and gentlemen, imagine if you were my client. Imagine all the pain, the horror, the pain and suffering that you are enduring every single day. Put yourselves in my client's shoes and imagine what her life is like. Imagine what this is going to be for the rest of your life. Imagine. So what we are trying to do by that argument is we're trying to get them to sympathize, to empathize with my injured client. And there's a key reason for that. The more empathy and sympathy they have for my client, the more they recognize and understand what it's like to be her. Now all of a sudden they're much more inclined to give my client a verdict in her favor. Why? Because they feel for her. They feel bad for her. They feel guilty. And now what do they want to do? They want to try and help her. Jason, almost happened to me. Wow. I calculated non-economic damages by using an analogy. Let me get this straight. For meals, the client couldn't taste anymore because of her services. Because of her severed lingual nerve. There was an objection from the defense counsel. We won, but the defense counsel used this as ammo to get us to settle for slightly less than risk an appeal. Wow, that's pretty powerful, and that's very, very significant. And Steve says, too bad I didn't have you back then. Wow, thank you both. Those are very important points, and it's critical to understand why an attorney cannot make this golden rule argument. So it would be really easy for me to turn to the jury and say, ladies and gentlemen, my client has suffered horribly. She's going to suffer for the rest of her life, which is going to be another 30 years. So I want you to step into her shoes and imagine what she went through when she went to Dr. Jones. And Dr. Jones did not treat her properly. He treated her carelessly, and as a result of that, caused her injury. And that injury resulted in all the need for all this ongoing care and treatment. And now, imagine if you had to go through that. Imagine if you, and so what I'm doing really is creating a picture in their own mind that says, hey, wait a second. I feel for her. I can imagine myself exactly what's going on. But here's something else. So attorneys cannot use that argument, right? So we can't tell the jury outright, hey, imagine if you were my client in her shoes. But instead, we have to come up with creative ways to do the same exact argument without using that argument. Now, what does that mean? Okay, so instead, we have to try and fashion an argument that says, ladies and gentlemen, my client went to Dr. Jones for this problem. He treated her the following ways, and now, as a result of his incompetence, as a result of his carelessness, guess what? She now suffered these significant injuries. And now I take them through exactly what her problems are and explain to them how this is going to affect her for the rest of their lives. So even though I can't use the exact words by saying, put yourselves in her shoes, I can create an argument that almost gets them to imagine what it's like in her shoes, by showing them what she is going through each and every day, by showing them the testimony that supports our claim that she suffered all of these injuries. That's why it's so critical to get these experts, to get these treating doctors to come into court, to go ahead and show the jury step by step exactly what problems they have, what things they cannot do, what things they can do, and now it gives the jury a sense of, hey, I understand that. I understand how she can't do these things every day now. I understand why she can't do her activities with her kids. And now they begin to get the sense, without me saying those words, put yourselves in her shoes. Now they still will understand, as long as you are creative in the way you do it, and plus, this is very important, have the evidence and the testimony to back up those arguments. So, again, what are we talking about today? The three more arguments that an attorney cannot make. So the first one is, that we're talking about today, that an attorney cannot tell a juror or jurors, can't tell the jury, put yourselves in the position of my client, and that's why I want you to give us a verdict in our favor. Okay? So let's see what else we have here. All right. So we made some good leeway here, taking up some good use of our time. Hang on one second while I take a quick break and I get a little cloud cover. All right. So we're on a roll now. So what is the second argument an attorney cannot make during today's conversation? The second one is an attorney cannot refer to jurors by name. Hey, Mr. Gold, nice to see you today. Today we're talking about why my client is entitled to a verdict in my favor. Thanks so much for being here, juror number 2. Now, how about this one? Same exact concept. Hey, Mrs. Gonzalez, thank you so much for returning to court for closing arguments. Can you believe what Dr. Jones said on the witness stand? I can't believe it. Mrs. Gonzalez, isn't it amazing to think that a doctor like this can have words coming out both sides of his mouth? Let me tell you why he's not credible. Let me explain why he's not believable. So by creating the impression that I know these jurors because I know their names, it would seem or would appear that I'm trying to create a bond with each of them beyond and over and beyond what I normally am allowed to do. And that's why an attorney cannot use this type of argument during closing arguments. Why? Because it probably would, give an unfair advantage to me, because now when somebody is called by their name, all of a sudden they're paying closer attention. Now all of a sudden they think there's a bond, and in fact there may be a connection there. And every time I refer to someone's name, a juror's name, all of a sudden they perk up and it's like, oh, he's talking to me. Oh, let me pay attention. Oh, what is it that he's saying to me? Okay? So jurors, at least in New York, and I'm pretty sure elsewhere throughout the country, are not allowed to go ahead and use juror names during the course of closing arguments. All right, so now we've covered two types of arguments that attorneys cannot make during the course of closing arguments in a civil trial here in New York. The first one is you cannot ask jurors to step into the shoes of the injured patient. And the second one is, hey, you cannot refer to jurors by name during closing arguments. All right, we are now up to number 3. So what's the third one? An attorney cannot claim that he has personal knowledge of the facts of this case, unless, of course, he does, in which case he would be a witness and would be an ineffective attorney, because now his credibility is at issue, even though an attorney's credibility is always at issue, even though he doesn't know the personal fact. He does not know personally the details and the facts of the case. Now, when I say personally, I mean that he's been involved, he's heard, he's seen events that went on that led up to this particular lawsuit. That's what I'm talking about. So if an attorney during closing arguments were to go ahead and to interject himself into the facts of the case, saying, ladies and gentlemen, I was there in the intensive care unit when my client's husband had a conversation with Dr. Jones. And Dr. Jones said this, and I overheard Dr. Jones tell my client's husband the following things. What have I just done? What I've done is I've now made myself an actual witness, a participant in the facts of this lawsuit. And 99.9% of the time, the attorney is not a participant in the events leading up to the lawsuit. In the very, very rare instance where he knows somebody, where he has a friend or relative and he happens to be in the hospital or talking to somebody, and now he hears or learns of based upon conversations. Now then he would become a witness. But during the course of closing arguments, an attorney can't turn around and say, ladies and gentlemen, I know this to be true. I know this to be a fact. How do I know it? Because I know my client, and I was there, and I saw everything that went on. If the attorney is a witness and heard or saw different things, now he might be able to argue that. But in all likelihood, he's going to have a very difficult time expressing himself to the jury, or maybe even getting the judge to allow him to continue as the attorney advocating on behalf of the injured patient, if in fact he was a witness to the events that led up to this lawsuit. So in almost every single instance involving a case that goes to trial, the attorney who is representing the injured victim is never, I shouldn't say never, is almost never an actual witness to the events. And in that instance, what that means is that an attorney can never turn around on closing arguments and say to the jury, ladies and gentlemen, I know for a fact that what this nurse said is absolutely false. I know for a fact that what this doctor said is untrue. Really? How do you know that for a fact? You weren't there. You didn't see it. You didn't hear it. You didn't know what to compare it to. You didn't have the evidence and testimony at the time it was going on. So how do you know for a fact? Instead, you now have to argue and use logic. You have to use reasoning. You have to use passion to show to the jury that based upon the conversations, based upon the evidence, on the testimony, the only logical conclusions is that the doctor who you have sued is not credible. The witnesses who have been presented by the defense are not believable. And as a result of that, your client is entitled to a verdict in her favor. That's what a good attorney does. Not use these arguments that I talked about today, which is, let me just recap here, the 3 additional arguments that an attorney cannot make during the course of closing arguments were, number 1, you cannot ask the jury to step into the shoes of your injured victim, the injured patient. Number 2, you cannot refer to jurors by name. And number 3, the attorney cannot claim to have personal knowledge of the facts in order to try and get the jury to reach the conclusion that his client is more likely right than wrong and entitled to a verdict in their favor. So, now you know 3 additional arguments. In addition, if you've watched the other video that we created the other day about 3 other arguments, actually 4 other arguments that an attorney cannot make during the course of closings. And if you have not seen them, I'm going to put a link in that so you can watch the other video as well. And this way it'll give you a total of 7 arguments an attorney cannot make at the end of a trial. And hopefully this has been eye-opening. Hopefully this has been educational. Importantly, I hope this has been entertaining. Now, if you have questions about your matter that happened here in New York, and you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516. Well, let me go. Wait. Don't miss this. Follow the bouncing finger. Ready? 516-487-8207. There we go. Or by email at Gerry. Here we are. Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I want to thank everybody for joining me. And if you're watching this on Facebook, please like it and share it with your friends. If you're watching this on YouTube, I ask you to do the same thing. And if you haven't already, subscribe to get my other great educational videos. That's it for today, everybody. I'm Gerry Oginski. Have a wonderful day. Bye-bye.